power of attorney, guardianship, conservatorship. What is the right thing for your loved one? Well, coming up, I'm going to give you a head-to-head comparison so you're going to know for sure. Hi there, I'm Sophia. Welcome to another video. If this is your first time here today and you want to be a more satisfied, more successful, and more informed family caregiver, then start now by hitting the subscribe button. There is a lot of misunderstanding out there between power of attorney and guardianship and conservatorship and what they are and when you need them and which is the right thing for your family member. So let me just go ahead and jump right in with a head-to-head comparison. The first thing that I need to mention right off is that with regards to this conversation today, the terms guardianship and conservatorship are interchangeable. In most states, the term guardianship refers to adults, while here in California, where I live, the term conservatorship is referred to when speaking regarding adults, and guardianship refers to minors. So in today's conversation, I am going to use conservatorship and guardianship interchangeably. So what are the purposes of power of attorney and guardianship? Well, a power of attorney allows you to choose a person ahead of time and designate them to take care of your affairs and your decisions if a day should come in the future when you're no longer able to make those decisions on your own. These decisions can pertain to healthcare decisions by completing a power of attorney for healthcare, or for finances by completing a power of attorney for finances. The purpose of guardianship or conservatorship is also to assign a person to be in charge of your medical or financial decisions. However, the difference here is that the decision about who is assigned is made by the court. When should these be implemented? Well, a power of attorney should be implemented while a person is mentally competent and able to make their own decisions and able to sign a legal document, because it is a legal document after all. Anyone over the age of 18 can fill out a power of attorney. If considering having your parent complete either type of power of attorney, these should be done before they get sick, before they have advanced problems with their thinking, such as with dementia or Alzheimer's. And hopefully it doesn't happen, but these should be implemented before there is a severe illness, such as a stroke or a heart attack or an accident. So essentially, if your parent is relatively well and mentally competent, these should be done now. On the other hand, a guardianship or conservatorship is implemented after a person has lost their capacity to make decisions about their important health care or financial matters. That is, if they haven't already filled out a power of attorney earlier when they were well. So when do these become effective? Well, a power of attorney can be created now and should be created now. While the person is mentally competent, it does not become effective until the person loses capacity to make their own decisions. And that could be years down the road or never. A guardianship or conservatorship, on the other hand, becomes effective immediately after the judge has made that determination. Now, how do you implement these items? Power of attorney is super easy to implement. You can do it yourself. You don't need an attorney to help you with this. As long as you have the necessary form available, which you can get from your bank for financial power of attorney, you can get from a hospital, or even download online for your state if you need. Then all you need to do is have it appropriately witnessed or notarized as whatever is required in your state, and you're done. I recommend you watch this video here if you'd like step-by-step instructions on how to complete a power of attorney for healthcare. I'll go ahead and put a link in the description below. You can choose to have an attorney help you with these forms and documents. However, just know it is not necessary. Implementing a guardianship or conservatorship can only be done by a court. Only a judge can determine if a person is indeed incompetent to make their own decisions, and if so, who's going to be assigned as their decision maker. You can be the one who initiates the petition for conservatorship or guardianship, but there is going to be a court investigation, and only after that will the judge decide who's the most appropriate person to assign. And what about your rights? Power of attorney does not take away your rights at all. In fact, it allows you to decide who's going to have responsibility for your affairs and under what circumstances. You maintain the right to indicate what you want that person to do or not do. As long as you remain able to make your own decisions, you are 100% in charge of those decisions. On the other hand, since the whole process of applying for guardianship and conservatorship is to deem a person incompetent to make their own important decisions, once this is decided by the court, then yes, that person has their rights taken away to make any of these important decisions. And what about the cost? Well, implementing a power of attorney is essentially free. As long as you have the form, the only cost that you might have is if you use a notary, which is going to cost you $40 or $50 or even less. And that's it. Obtaining a guardianship or conservatorship is much more expensive. You are looking at obtaining services of an attorney, which could cost you thousands of dollars. If you are the one seeking to be the conservator and you're low income, you might be able to find a local legal aid service in your county that can help you so you can avoid the attorney costs. And there also may be court fees involved, but again, if you are meet the limit for low income, you can ask the courts to waive those fees. Otherwise, you're looking at several $1,000s in attorney and court fees. And how long does it take to implement? Well, a power of attorney is immediate. Just obtain the forms, have them witnessed and notarized as appropriate in your state, and you're done. Obtaining guardianship or conservatorship is a court process, and we all know how fast our court system can be. So this can generally take anywhere from 2 to 3 months. That's a best case scenario, and it can take up to a year. If there's people who dispute the petition or there's extenuating circumstances, these are things that can make the process take longer. And what about revocability? With a power of attorney, the document can be revoked at any time, whenever you want, as long as you're still competent to make that decision. You can change it or reassign the person who's going to be your decision maker, anything you want at any time. With a guardianship or conservatorship, once the order is issued by the court, these are usually for the lifetime of the person involved, unless the court decides at some point that they need to change it. As you can see, the benefits of implementing a power of attorney for healthcare and or for finances clearly outweighs doing nothing and risking the need for conservatorship later on down the road. You will have the peace of mind, maintain control, save a lot of money, and save your family a lot of stress if you put these important documents into place now. So just set them up now and forget about them. If you have any questions about power of attorney or guardianship, then go ahead and leave them in the comments. I'd love to hear from you. If you found today's information helpful at all, then please go ahead and hit the like button. And if you don't want to miss any new videos on everything senior, then please subscribe and hit the notification bell, because I release new videos every Tuesday and you're not going to want to miss out. Here are a few more videos that I recommend you watch to help you in your caregiving journey. I thank you so much for watching today, and I'll see you next time.